Good afternoon. Welcome to the Center for Comparative and Public Law Lunchtime Seminar. Today we're extremely honored to have Professor Richard Ekins to talk to us about statutory and constitutional interpretation and the separation of powers. Professor Richard Ekins is a tutorial fellow in law at St. John's College and an associate professor at the University of Oxford. After completing his undergraduate studies at the University of Oxford, he went on to Oxford to read the BCL, MPhil, and DPhil. He's worked as a judge's clerk at the High Court of New Zealand at Auckland and a lecturer at Balliol College, and was a senior lecturer in law at the University of Auckland for several years before moving back to Oxford. He's an editor of the Oxford Journal of Legal Studies, and he leads Policy Exchange's Judicial Power Project, and with Nick Barber, the Program for the Foundations of Law and Constitutional Government. Thank you, Richard, for coming all the way to give this talk. We look forward to hearing from you. Thank you very much. Let's welcome Richard.
Very kind. Thank you, Cora, and thank you to the Centre for giving me an opportunity to speak to you. And I'm looking forward to learning from you in turn. So as the abstract of the talk suggests, I'm interested in statutory and constitutional interpretation. Much of my work has been in, if you like, the jurisprudence of interpretation and lawmaking, and my doctrinal background and expertise is in the Westminster context in particular. But I have broader interests in comparative constitutional law, which I will speak to some extent today. So my aim is to think about today what interpretation is and how it relates to the separation of powers. And I'll think to some extent about how this might differ between the context of ordinary legislation and constitutions, capital C constitutions. And perhaps rashly, I will try and say a little bit about how this might bear on Article 158 of your basic law. Well, at that point, as will be obvious, I'll be beyond my specialty. So I want to go back to the beginning, if you like, to the foundations of justified government. And my thought here is that before one can get to separation, one needs unity. And so one can think about the separation of powers and its rationale by reflecting on unified royal authority. Common good requires government, requires the exercise of authority, and that can most straightforwardly and most simply sometimes be realised by a single person ruler. And that single person, who we might call the king, will rather quickly, I think, if reasonable, recognise the need, when conditions permit, to set up other bodies to help him rule. Not just servants to execute his or her present will, although that will be important, but judges to give justice in his name, to fairly apply the law to disputes as they arise. So the king will create, will maintain, will support, and will also oversee and check these courts. And the king will also invite others to join him in his decisions, especially those major decisions that might concern the raising of funds, the changing of general law. And the changes that will be approved, or that are approved by way of the approval of the group drawn from the kingdom at large, those changes will be better than they would have been if undertaken by the king alone. They'll be better informed, they'll be more secure, more stable, they'll likely be more effective, more likely to be implemented in the way that they are intended. So one sees here the rationale for separating adjudicative and legislative authority, for differentiating different articulated modes of government in Jeremy Waldron's term. The expansion, or the introduction and expansion of common law courts, the introduction of parliamentary lawmaking, those were initially, in the English experience at least, more generally, instruments of royal will. They were ways of kings making themselves stronger by making themselves less free, joining the kingdom as one in action, ruling by law. Now, it wasn't all sunshine and light, of course. The seeds of conflict were present in this scheme very early on. The destructive exchange, culminating civil war between king and parliament, kings and parliaments in the English history was there too. But the rationale for the separation of powers is found in this history, in this scheme, I think. Well, let me turn to the powers in a bit more detail, each of the powers in particular, beginning with the legislative power. And the way to think about this, in my view, is to reflect on the need that it answers. And that need is for law to be made and changed deliberately. Part of the virtue of living under law, is that law is artificial. It can be made, repealed when reason demands, it can be changed as appropriate. However minor or major the change required, been made and changed in precise form, fit for the rule of law, if you like. And reasonable lawmaking requires freedom and it requires capacity. It requires to be a lawmaker who is able to change the law and is free to do so when there's good reason to do so. So whoever is charged with legislative authority, legislative power, should stand ready to change the law, should think about the ways the law could or should be changed, and should develop, work up, evaluate proposals for lawmaking change. And that requires a complex mix of types of reasoning. It requires moral reasoning, empirical reasoning, what's actually going on, technical reasoning, craft, put choices in the right frame. And in the end, it requires the exercise of choice. Legislating is choosing. It's choosing what the law should be. It's adopting new legal propositions as a means to some aspect of our common good, perceived aspect at least. A way of making our world better by changing the law to bring about some new set of social ideas. And the need for legislation comes before the identity of the legislature. In other words, a legislative assembly is charged with the same responsibility, undertakes the same task as a king does. Doesn't mean there's not a good reason to authorise an assembly to legislate. It certainly is. Authorising an assembly is a very prudent and sensible decision, helps restrain the risk of tyranny, doesn't avoid it altogether, but does minimise it. Enables public participation in lawmaking and improves the quality of legislation. But what's required, so in a sense what legislation is still reasoned choice, regardless whether it's a king legislating, a king with his assembly, or an assembly alone. Let me turn to judicial power. Now, judicial power, as I said, is a response to the need. And the need is for adjudication, for authoritative, fair settlement of a dispute, some dispute, in a way that brings general law into relation with particular facts, defines the particular facts, and governs them by the general law that has been earlier established. Now, often, of course, what is in dispute is the meaning of a statute, and the court settles that meaning in the course of its adjudication, deciding which party's understanding of the governing law was correct, if either were, adopting some third alternative. But it's a mistake, in my view, to think of courts as having a power of interpretation. The authority of their interpretation, and it is authoritative, is an adjunct to their exercise of the adjudicative function, and an upshot, in the common law system at least, of the effective precedent, whereby their decisions are a source of law themselves and bind subsequent courts, at least in some respect. But talk about a judicial power of interpretation is awfully common, and to my mind is sometimes mischievous, does some harm. Let me just consider a few ways of thinking about a judicial power of interpretation as such. It's sometimes equated with a judicial power to control legal meaning. So effectively, a power to veto legislation of which courts disapprove, legislation they think unreasonable, at least to veto it once, to force the legislature to try again, to enact legislation that makes its position still clearer, crystal clear, if you like. And even such a great exponent of the parliamentary sovereignty as Albert Venn Dicey, the Victorian jurist, adopted a view that had something in common with this. Now, less radical, although still fairly radical, is the realist thesis. Legislation is standardly incomplete. It doesn't itself establish law, it establishes the sort of preconditions for law, if you like. And it's specified by judges in the course of application. Judges make it have a certain meaning, certain concrete application in the course of adjudication. Joseph Raz, the Oxford legal theorist, whose work you'll be familiar, took the view that, or takes the view still, rather, that interpretation is backward-facing and forward-facing. In other words, when courts interpret the law, as they routinely do, they conserve part of what's gone before, but they also innovate for the future. So there's a lawmaking function built into the idea of interpretation on Raz's view, and that's a view brought out and articulated in the work of some of his successors who work more squarely in constitutional law. Now, for my part, I think it's actually best to try to do without the idea of interpretation as far as one can. It's a bit odd for a person who's giving a talk on interpretation, and I'm not, as it now implies, skeptic about interpretation. Just think that the idea of interpretation sometimes gets in the way. And it can be helpful to think up what courts should be doing, how we work with legal materials, without the idea. Arrive at a conclusion, what the idea is at the end, if you like. So I think we should avoid reasoning from the idea of interpretation to conclusions about what courts should or may do. And that view, which I've just suggested, might seem similar at a surface level at least, to an argument of Cass-Sunstein's, which he's articulated in a series of recent book chapters and articles, to the effect that there is nothing that interpretation just is. And that phrase is the title to a book chapter of his and then to an article which I've responded to, and which he's responded to in turn. Now, in fact, there's a surface similarity, but in reality, it's quite a marked difference. Sunstein wants to liberate judges, wants to liberate them to do whatever they think is best with legal texts, provided they are working with the text in some way, and that's intended to be an extremely loose constraint. And he wants to liberate them this way, or his ground for liberating them, if you like, is that the term interpretation can be understood in a range of wildly different and incompatible ways. So it's a very broad sense of a plausible alternative in one's construing the word interpretation, the idea of interpretation. And provided you're within that scope, that very broad scope, you're on safe ground as a judge, in Sunstein's view. Doesn't mean that anything you do is proper and right, but it's up to the judge to adopt whichever account or approach he thinks or she thinks or they think is best for their time and place. Now, I think on the contrary that the meaning of the term interpretation isn't decisive here. It's not really relevant to determining what it is that judges or courts should do. It's the nature of legislative power and its exercise in particular cases, making or unmaking some particular statute, that settles how courts and others should respond to legislation. It settles how they should interpret, if you like, statutes. And the standing risk here is that courts, or others, especially courts, will distort or depart from what the legislature chose. And that standing risk explains, it's not a new thought, obviously. It's an old worry on the part of lawmakers. Now, I'm no expert in Roman law, but I understood that Justinian had forbidden the interpretation of the laws, of the statutes he promulgated. Forbade that interpretation on pain of death, even, which is a bit radical. Jeremy Bentham, likewise, thought the interpretation of statutes was an arbitrary power, which should be withheld from judges. What did he want judges to do then? Well, he wanted them not to go beyond the literal meaning of the text that had been enacted. He wanted them to refer unclear matters back to the legislature for decision, rather than to take it upon themselves to make the decision that he made. Now, in that account, which, as with all things by Bentham, is quite obscure and baroque and hard to follow, I don't think he meant literally. He meant follow the clear intended meaning of the legislature, as I understand. Now, his proposal for referring cases back to the lawmaker is intriguing, and might seem in a way to anticipate Article 158 of your basic law, we can discuss later. But it's a problematic proposal in a few ways. It's problematic because the composition of the legislature, of course, changes. So you refer it back to the lawmaker decision, but by the time you do, the lawmaker has changed. We can't report to you the decision that was made, or that it or they made at the time. And in any case, the temptation for the lawmaker, maybe the invitation to the lawmaker, when you refer the matter back, will be to impose their present preferences, to make the decision they now would like to make, rather than the decision that was made at the time, should have been clear at the time. So a reference back to the legislature in this way might be a pretty poor way of recovering the decision that was made and that was intended to have been made clear in the past, and avoiding the risk of lawmakers simply pursuing their present plans and goals is part of the point of separating adjudicative authority in the first place. Part of the virtue of having independent courts that adjudicate disputes fairly. Well, I take judges, like every other subject of the law, to be obliged to uphold the legislature's decision. And they may at times have to apply to carry forward vague, incomplete, morally loaded rules, if that's what the legislature has chosen. And in a sense, this isn't interpretation properly so called, not identification of a decision made in the past by the body with authority to make it. It's the application of decision made by another, maybe difficult and complex application, different type of exercise. And there's a useful discussion, if you're interested in following up, by Timothy Endicott, reflecting on what interpretation is and is not, and discerning the difference between these modes of activity. Well, my main interest in this talk today is in legislative and judicial power and the relationship between the two of them. But I want to mention the executive power in passing, and it does have some implications for how one thinks of interpretation, I think. And the executive power is poor cousin of separation of powers, often overlooked. And that's a little odd in one way, because plainly it's a very significant mode of governmental action and power. And in one sense, the reason it's overlooked, I think, is because it's everything else. It's all of governing left over when you separate the legislative power, the legislative task, and the adjudicative power. There are extremely good reasons, as I've suggested, maybe too briefly, for separating the judicial power, separating the adjudicative power. Much trickier to thoroughly separate executive and legislative power. In fact, it might be quite a mistake to try to separate them too thoroughly. They need to be closely integrated. And they need to somehow have to stand in the right relation with one another for there to be good government. And to be democratic government too, one might add. And what one wants from a constitutional order in this respect is an executive-legislative relationship that enables and constrains both institutions. And it fosters a dynamic, political, constitutional dynamic that controls, disciplines, directs, and supports robust executive power. It's no good if the executive is too weak. It's no good if it's aimless, and if it's uncontrolled, undirected. And there are different ways of attempting this balance, of course, as you'll be fully aware. The Washington and Westminster models are well-known ways of doing so, and they give rise to quite differently constituted legislatures. The Washington legislature is structured, I think, in a way that's less capable of coherent action, reasoned action, than is the Westminster legislature. And there are some advantages, corresponding advantages to its structure, but the separation of the executive and its peculiar internal arrangement does give rise to this feature, I think. And it might then not be a surprise that what you find in the Washington system is a certain freedom for executive agencies in relation to interpretation. So executive agencies in the United States are free to act, and free in a way to make law by virtue of a license to interpret their empowering legislation, the act that empowers the agency in question. With the courts largely staying their hand, failing to intervene, to correct, to overlay the agency's interpretation of their own powers and their own charter, if you like, with judicial understanding. Doesn't mean the agencies are free to do as they wish. In fact, the absence of thoroughgoing judicial oversight makes more significant the political accountability to Congress and to the present Congress's preferences. Now, I'm an Anglo-New Zealand lawyer. I spent my life and my professional life in New Zealand and the United Kingdom. So I've never lived under a written constitution. I should take that as a caution when I come to talk about it. I do so as an outsider. And to my legal training, this sort of chevron structure, as it's known from the leading US Supreme Court case, this is an odd way of framing government, to let agencies have this independence of manoeuvre. But it seems, I think, on reflection, an intelligible response to their wider separation of powers, a response to the need for there to be someone who's capable of making law, capable of acting and making decisions that need to be made. Not without accountability, without check, but making sure there is such a body ready, present, and able to act. Quite different in the Westminster scheme in other parts of the common law world. So the practice of statutory interpretation, on my view, it centres on recognition of the nature and exercise of legislative power. So the legislature, as I see it, is a body that's responsible for and capable of securing the common good by choosing to change the law for good reasons, reasons at least that seem good to it. So courts, like other persons, other bodies, should respond to statutes as reasoned choices, not just see them as a mess or as raw material on which to work. So courts, like others, should aim to infer and then to uphold the legislature's intended meaning. And if they compromise or distort that choice, that meaning, then they undercut the separation of powers in relevant part. They make law themselves under the guise of adjudication, and that's standardly, at least, an unfair mode of lawmaking, ill-informed compared to the alternative mode of lawmaking, and it's retrospective in effect. Now, none of this means you shouldn't reason about what the lawmaker should have done in legislating. And that reasoning about what the legislature, with a good reason to do, that is highly relevant to working out what the legislature in fact did. But it's reasoning in service to an inference about what the legislature did choose in the past. Now, relatedly, I think one should be slow, maybe very slow, to entertain the hypothesis, or to allow evidence to the effect that the legislature has abandoned its duty, that it's not seeking to secure the common good, that it's not trying to respond to reasons that are good as public reasons. So one should look when one reads a statute, for the reason choice that seems to explain promulgation of the statutory text, a set of sentences that make up the statute. Reasons that explain the promulgation in the particular complex context in which it falls to be understood. And that context, I should be clear, is the context of enactment, not the context of adjudication. Adjudication turns on finding and then maintaining the law as it was when adopted, as it was introduced and thereafter continued, which the legislature acted to introduce and hasn't yet acted to or replace. And obviously that choice of context, or the question of which context is controlling, makes quite a large difference to how one reads a statute. I think it's unquestionably the orthodox view that the context of enactment is controlling, but there are certainly hints throughout common law practice that it's the position now that matters, and one finds that tension playing out in relation to different controversies at different times. Part of the context of enactment is the separation of powers itself, and the Constitution more generally. Capital C Constitution, if you have one, small c Constitution otherwise or in addition. It's part of the context of enactment, part of the background against which one construes particular enactments. And the idea that one receives statutes on the presupposition that they are not intended to distort, displace, destroy the existing Constitution, that does quite a lot of work. It saves time for legislators, I think. It rules out various, or at least bears on the weight of various competing arguments. And the so-called, because I don't think it's a very good name, the so-called principle of legality does capture part of this idea. My friend Philip Sales, who's a Law Justice Appeal in England, has suggested that it's better termed the principle of sort of minimal impairment of the existing constitutional order, which is much less snappy, but maybe slightly more accurate. And he shows, I think, rather conclusively that it's a mistake to confine the principle of legality to the context which it sometimes is articulated, namely constitutional rights. It has a broader sweep to concern other constitutional principles, other arrangements. So, be slow to conclude that the legislature has unsettled long-standing arrangements. That includes settled rights, certainly. It includes also the allocation of powers, the allocation of responsibilities to different institutions. Now, there are various ways of going wrong in applying the principle of legality. And notwithstanding, I think it's broadly sound. I think it's a principle that can be dangerous and that can turn on itself, if you like. It's a way of courts, it's an empowering doctrine for courts in some ways. And if not carefully observed, if disciplines are not observed, it can undercut the separation of powers in part. I thought I'd just mention two English cases where this recent and prominent English cases where this may be evident. And one or two of these may be familiar to you, perhaps. First one, probably not, but it's called Evans and Attorney General, a case concerning the Prince of Wales' letters to ministers. Prince of Wales had a bad habit, I think, of sending memoranda to various ministers of the Crown, opining on his views on various subjects. And the question, which was posed by a Guardian journalist, was whether the government should be releasing these letters. The government wasn't very keen so to do, and so the Freedom of Information legislation was put in motion to force their release. And the question so multiple courts had to consider this, the legislation was changed and so forth. And almost the end of the saga was the decision of the UK Supreme Court in Evans and Attorney General, where the question concerned how to construe the Attorney General's statutory power to limit disclosure of official information, to limit it when the Attorney General took the view that the balance of public interest was not in favour of disclosure. And the Attorney General had that power, it seems pretty clear, even if a tribunal, which in the upper tribunal in the United Kingdom is the Superior Court of Record, even if a tribunal had ruled that the balance of public interest was in favour of disclosure. The question was how to understand and how to deal with a challenge to the attorney's exercise of that power. And three of the judges in the Supreme Court, led by the President of the Court, construed that power in a radically circumscribed way, construed it so as to be almost non-existent. It still had some nominal purchase, but only in facts that would almost never arise. And they did so because they thought that the statutory power did not fit with principle, did not fit with the separation of powers, or relatedly the rule of law that the separation of powers secures. Now, in fact, I think that assessment of principle was misconceived. It was formalism, if you like. It took the decision of the upper tribunal to be the same as the decision of the High Court in a murder trial, rather than to see the particular loaded public interest character of the decision. But in any case, even if the majority were right, their inference about principle should have yielded to an extremely clear decision made and articulated by Parliament on point. And the refusal to do so was licensed, or at least rationalised by invoking the principle of legality. Now, a little bit different is another case, which maybe many of you will have heard of, I think. One of my colleagues, I believe, spoke on recently here at HKU, which is the case of Miller and the Secretary of State for exiting the European Union. It's the Brexit litigation, Article 50 of the Lisbon Treaty, whether the UK government could initiate exit from the European Union after the constitutional referendum in 2016, or whether it required primary legislation to initiate the action. It's a very interesting case in many ways, but the important point for present purposes is that the court relied, or the majority relied on the principle of legality, but turned it round, inverted it, if you like. It said that nothing in the European Communities Act of 1972, nothing in that act preserved the government's prerogative power to withdraw from treaties. Therefore, that power did not exist, did not continue. But the better analysis would be that that power, which the court wasn't very keen on, is constitutionally long-standing and significant. And before one takes that power to be eclipsed, to be removed, one should expect to find clear legislative decisions so to do. And that certainly was not there. So the principle has been turned on its head. And in a way, in the United Kingdom, statutory interpretation often has this constitutionally loaded and fraught character. The doctrine of parliamentary sovereignty limits judicial supremacy in a range of ways, limits it quite clearly, but it does encourage a certain kind of adventurousness in determining what it is that the legislature has decided in the first place. Well, let me turn from there to constitutional interpretation, properly so-called, rather than the odd mode that we have in the United Kingdom, to some extent in New Zealand. Is the Constitution with a capital C an enactment? Well, in some jurisdictions it clearly is. So the Constitution of Australia undoubtedly is an enactment of the Imperial Parliament. Other jurisdictions, the United States, for example, less clear. Not a statute adopted by an ordinary legislature, certainly. And so the question, in one way, is how was the Constitution made? And the reason to ask that question is because it might bear on a subsequent question: how should the Constitution now be understood? The idea that statutory interpretation centres on inferring and recognising an exercise of authority by the legislature, that's relatively uncontroversial, at least by comparison to the corresponding claim in relation to constitutional interpretation, namely that interpreting a constitution centres on recognising the authority of the constitution maker. Now, it's true, I think, that in many places the identity of the constitution maker is less clear, and the constitution maker may have less of a stable, permanent, enduring character than is the case with the legislature. Nonetheless, the Constitution, capital C, does seem to me, as an outsider, to be law made deliberately, and insofar as it is, falls to be understood like other statutes, like other enactments, if you like. The context is different, or at least somewhat different. and that will certainly weigh on how one infers the decision in question. But the basic structure looks to me to be the same. Interpretation centering on identifying what was done then, a point in the past, by way of an exercise of lawmaking power. Still, one has to recognise there are differences here, and maybe quite significant differences. The Constitution is different to an ordinary statute, at least insofar as how one changes it. It's going to be difficult to change, and more likely than not, it will not be subject to the ongoing oversight of a legislature that is perpetually in session, or more or less perpetually in session, as is the case with ordinary legislation. And that may mean that the enactment, here I mean the Constitution, becomes problematic over time. And this point gives rise to, or it means that pressure may arise, rather, to change the meaning of the Constitution, to achieve a lawmaking change by way of adjudication, on the simple premise that it's not likely otherwise there will be the change that is required. So the idea of interpretation as a kind of low-level lawmaking, incremental bounded lawmaking, arises with particular force in the context of constitutional interpretation, and maybe is particularly prevalent in that context. And one should add that it might be that the practice of constitutional interpretation may shift, so that one is no longer focusing on, no longer interpreting the Constitution as an enactment, or no longer just interpreting it as a decision taken in the past which it continues to control. Instead, the object of attention becomes the Constitution as a series of authoritative interpretations, as a series of decisions that arose from, that began with the Constitution, but which are more significantly, more relevantly, the series of workings with that enactment by the adjudicative bodies that follow. In other words, one ends up with something more like a common law practice, practice of working with principle laid down in succession of cases, none of which are themselves authoritative, rather than the business of inferring a decision made in an enactment. Now, I don't think that's a terribly good state of affairs to find oneself in. It's unstable. It's always open to a collapse back to the original decision, to appeal to it. And that's part of the rationale for the scheme in question. You see this in the American constitutional practice, where sort of an ongoing seesaw between a series of particular changes later made and then appeals back to the authority of the original act in some way. And it's a difficult mode of lawmaking and constitutional practice if one's concern is, as it should be, in part to maintain the rule of law and to maintain good government, intelligent self-government over time. And that might be a reason to be cautious about constitutionalising matters, to be cautious about over-constitutionalising, or at least to make effective provision for intelligent, deliberate amendment, not to rely simply or mainly on lawmaking by way of so-called interpretation in the course of adjudication. Well, I want to turn, as I said at the start, to your basic law, subject to all the caveats I added before. And all of this may be wrong, and I may have missed some highly significant facts on the ground, which I look forward to hearing about when we turn to a broader discussion. If I've read correctly, and I may not have, the basic law is an enactment of the National People's Congress, but one adopted, of course, in a particular and unusual context, following Sino-British Joint Declaration, facilitating the return of Chinese sovereignty, making provision for the one country, two systems arrangement. And looking from outside at least, it looks as though Hong Kong has a remarkable degree of autonomy as a subset of a larger sovereign state compared to communities elsewhere. But that's autonomy, of course, that's subject to various reservations, subject to oversight of different kind. And Article 158 seems to be the heart of that structure, unsurprising, reserving power or authority to determine the meaning of the basic law to the Standing Committee of the National People's Congress. A reservation of power and authority that goes hand in hand with the delegation of that power and authority to the Hong Kong courts. By delegation, I mean an authorization of the Hong Kong courts to interpret basic law in the course of adjudicating disputes. It's highly sensible, otherwise one would be very difficult to have decisions in action and law. So Hong Kong courts are free to take their own view to some extent about what the basic law means in adjudicating disputes. Subject, as I read it, to a duty to refer some questions to the Standing Committee rather than making the decision themselves. So the echo of Bentham part. Now this reservation of final interpretive authority to the Standing Committee seems to be similar to some arrangements one finds elsewhere, historically and in present-day practice. Similar in part, but also different. The major differences rapidly eclipse the similarities. So similar in one way to the state of affairs that prevailed in the United Kingdom before 2009, where the final appellate court in the United Kingdom was a committee of the House of Lords, a committee of the upper house of Parliament. A committee consisting of professional judges who were appointed to the House of Lords in order to be members of that committee. Similar in a different way to what follows after the House of Lords' role, though, the United Kingdom Supreme Court's role as the authority in relation to the UK's devolutionary settlements, where it's a national court, a national institution that determines the meaning in the end of those devolutionary statutes and ensures that Scotland, Northern Ireland, Wales, the bodies therein, courts of Scotland or Northern Ireland, don't misconstrue their charter, if you like. It's subject to overall control. Now, that's overall control that is less significant in a way than the control exercised by the United Kingdom Parliament, which can just change those statutes. But that integration in a larger body, a larger adjudicative body, seems to be parallel there. But of course, the UK Supreme Court and the UK House of Lords are both courts. The House of Lords was in relevant part. And courts, moreover, that act within an ordinary appellate hierarchy and structure. Now, the way the reference to the Standing Committee has something of a parallel in EU law, in the reference to the European Court of Justice of unclear questions of EU law. It's a duty on national courts, a duty often breached, but a duty clearly there in EU law and in its adoption in national law, a duty to refer unclear questions about the meaning of EU law to the European Court of Justice for clarification. Often in the midst of adjudication, pause the dispute and send a matter off to the ECJ, and then you resolve the dispute in line with the interpretation that is received or returned. But as I understand it, the Standing Committee is not a court and doesn't resolve a live dispute put to it by parties subject to argument, etc. Now, I did briefly wonder if Article 158 was limited, if it limited the role of the Standing Committee to matters that should be referred by the Hong Kong courts, so that, if you like, the authority of the power of the Standing Committee was devolved to the Hong Kong courts, and then its authority and capacity to decide questions of interpretation was limited to matters that were referred back to it, or should be referred back to it by the Hong Kong courts. Now, I didn't think that was the case in the end, having read it a few times, and it seems the Standing Committee's implicit interpretation of Article 158, I don't think it's expressly interpreted, or you can tell me if I'm wrong, is that the article is not limited in that way. In other words, it has a more free-floating capacity to introduce interpretations of the basic law. And it does seem to me to make it the case that interpretations of the basic law have the form of pseudo-legislative acts, promulgated in a canonical form, promulgated sometimes on the Standing Committee's own initiative, not always obviously limited to past legal materials. Sometimes they seem to stress the importance of adhering to the original legislative intent. Sometimes they seem to go, at least to my reading, to go well beyond it. And they seem, maybe at times, to be animated by a concern about the consequences in the future in a way that might be improper for a court to entertain, save in the sense that the legislature, making its decision in the first place, would have wanted to avoid or secure certain consequences. But a more free-floating concern for what will happen next if, that's more appropriate for a legislature than for a court construing materials. So there's a standing risk, if this is right, of lawmaking by way of Article 158. Lawmaking that might prejudice existing litigation, that's not disciplined in the way that ordinary legislative action might be or should be. and a risk, I would have thought, of Article 158 undercutting Article 159 and the power to amend the basic law altogether. So the Standing Committee, I would have thought, should be aiming, whether or not, any different question, should be aiming to uphold the settled terms of the basic law. So to prevent Hong Kong authorities, including Hong Kong courts, drifting away from them, and doing so especially where there's a particular point of connection to wider interests of the People's Republic. But the risk of the Standing Committee subverting the basic law would seem a very real one. Not a unique risk, of course, it's a feature of constitutional orders more generally. And it's similar, perhaps in form at least, to the position one finds oneself in other jurisdictions where a Supreme Court is effectively unaccountable and feels itself free to remake the law in the course of adjudication. Now, there are tricky questions, doubtless, for the Hong Kong authorities, especially the Hong Kong courts, in interpreting the Standing Committee's interpretations, especially if they are effectively lawmaking acts of the kind, including how to reconcile those acts with the truly authoritative material, so the basic law itself understood as a lawmaking action in the past. And I did wonder, and maybe I'll just suggest this now so someone can put me right during the discussion that follows, whether there has been any discussion about the possibility of interpretations by the Standing Committee being ultra vires, exceeding the scope of authority conferred by the basic law, or being so flatly inconsistent with the terms of the basic law as not to be interpretations. And this all puts me in mind of a similar dynamic and a similar set of worries one finds in the European legal order, the EU, where the terms of the EU treaties have been interpreted in some very surprising ways by the European Court of Justice, creating much concern on the part of some member states, especially the member state that's in the course of leaving the European Union, namely the United Kingdom. And there have been attempts in various member states, most notably Germany, but recently, and probably now just as a matter of historical record in the United Kingdom, attempts by member state courts to articulate grounds on which to resist problematic interpretations of EU legal materials by the ECJ. And grounds that would be not permitted as a matter of EU law, but might be permitted as a matter of domestic law. Obviously, I mean, those attempts have been good to talk about, but maybe not terribly effective, maybe of diminishing effectiveness over time, in fact. They had more significance early on in the development of the EU legal order, much less than now. And obviously there's a radically different political dynamic at work. So let me just bring this to an end. I won't say a tidy end, but to a conclusion of a type. Interpretation of statutes and constitutions is framed by the separation of powers, and that's a separation that requires discipline and restraint, but which opens up many different opportunities for separation, that separation to be undercut, to be compromised. And the challenge of securing constitutional government is to foster a political, constitutional, legal culture, legal practice, in which those disciplines are taken seriously, are appreciated, are observed. I think I'll stop there and await your questions.
That is absolutely fascinating. I have a lot of questions and comments,
Very good.
but I think I should first open up to the floor in light of the time constraints. Questions or comments? Yes, please.
First of all, thank you very much for this really interesting talk. So you seem to be quite skeptical, if I may say, against the idea of judicial interpretation. But let me first make sure that I understand what that means, okay? So suppose, okay, so the legislature, so I understand that you think in deciding a case, okay, the first priority should be to ascertain the legislative intent, okay? However, sometimes the legislative intent could be indeterminate, okay? And then the court has no choice, okay? But to, well, basically, like, so for example, it could have possible meanings A, B, and C, and the court must choose, okay, based on some considerations. There's nothing to do with legislative intent. I would like to think that this is a paradigmatic case of interpretation. Basically, that in some parts of your paper, you think that could be acceptable. So can you, like, elaborate a bit on, like, where that is interpretation, and if that is so, is that acceptable form of interpretation? And the other question is that, as I understand it on your field, the reason why we should resist a more expansive understanding of judicial interpretation is that we should respect the authority of the lawmakers. But I would like to think that, well, of course, that's one consideration, but there's just one consideration amongst many others. So, isn't it true that how much deference we should give to the authority of the lawmakers would depend on, for example, the subject matter? So we may think, for example, in matters of policy, we should give more deference, we should respect the authority of the legislation more, but in matters of principle or rights, we should trust the legislature a little less. Okay, so some may think that. And it also depends on how the legislature is formed. So if it's a really wise king, okay, then we may respect him more. But if the king is rather stupid or I will not go into details, but we can the lawmakers are very well formed.
Insert appropriate analogy, okay.
Yeah, so these are two questions.
Okay, well, those are excellent questions, thank you. Maybe my talk does sound like I'm skeptical of judicial interpretation. In a sense, I have encountered what I think courts should be doing when they interpret statutes or constitutions. Obviously, it's a central function of any person advising someone about the law is, or any person finding the law, including courts. So it's not that they shouldn't do it, it's a question of what they should be doing. And so my account, I think in common with the common law tradition and its parallels in civil law, does stress the significance of legislative intent as the object of interpretation. And I don't accept the premise, really, or at least I want to resist the premise that legislative intent is standardly indeterminate, or is often indeterminate. Maybe even say standardly. I'm foisting that on you. And often it's hard to determine, and that might be especially hard to determine in those cases that come before the courts, precisely because if it was really clear, we wouldn't end up having this argument. And there are reasons that point in one way and reasons that point in another, and there are options A, B, C, as you suggested, for how one could read this statutory text. Now, there are options A, B, C, I think, because there are live contenders for what it is that was decided and intended in adopting this form of words in this context. Or, if you like, an intelligent decision maker creating a law using this form of words might be intending any of these alternatives. So what do? Well, we infer which we think was intended. We do so from the available evidence. The available evidence includes the grammatical force and stress, its coherence with the rest of the statutory text, the existing context, judgments about which of these alternatives make sense, which is self-defeating and absurd, which was, and so forth. And one makes an inference on that ground. Now, the court's inference could be wrong, and I think it's the job of courts is to make decisions conscientiously, but so that it's a routine feature of adjudication, you make the wrong decision. You should still be bound by the wrong decision, provided it's made conscientiously and without corruption and so forth. So courts might get it wrong. In one way, they can do no other, I think. Simply try, do your best to infer what was in fact intended. If you told me there are multiple ways in which the statute could be read, here are the alternatives, I would think those are live alternatives for what was intended in the adoption of the statute. Now, of course, if one takes a step back and says the legislature is a chaotic mess and often makes statutes without intending anything at all, well, it's possible, but I think it's less possible than one might think because of the way in which legislatures are structured. And much of the work I've done is precisely to try to show how it is less far-fetched than one might think to imagine that a large assembly could actually arrive at agency. But the second question here is an intriguing one. Isn't legislative authority just one consideration amongst many? And my argument is no, it's not. It's the consideration, to which many things are relevant. And so I tried to stress, whether I did so successfully or not, that there's certainly room for evaluative reasoning and working out how the authority was exercised. It's not a matter of reading off from the grammatical words, context, etc. And partly creating an image of what you think a reasonable decision in this context looks like. But you're bound by the decision that the various cues suggest was in fact made. Now, different legislatures are more or less capable, and my account requires, it's not a good one to be adopted if your legislature is standardly evil, incompetent, etc. It would be a mistake to treat it as authoritative. It's difficult to do that as a matter of legal doctrine, but it might be this, one should qualify the legal practice accordingly. I think there's a time and place to disobey the law, but I think a coherent legal philosophy that supports it. I think, though, and so the account I'm giving in one sense is is insufficiently attentive to particular accounts of the capacities or nature of the legislature. Although I would say, I think the account you have to adopt should be should allow for episodic failures of the legislature. So the fact that the legislature from time to time is not making good decisions is consistent with adopting a different scheme more generally. And I don't buy the principle versus policy distinction, which you were relaying to us by way of the great late Ronald Dawkins. So I don't think that's the way we. I don't think that's the responsibilities of legislatures are not limited to questions of policy, nor is their expertise. They have to routinely reason about principle and can often do so well. Maybe in some cases they don't. I mean, the reception of statutes against a constitutional backdrop answers part of this concern. But in a sense, whether we should defer the legislature is a different sort of question. I think we're trying to figure out in the first place what is it the legislature has decided on the premise that it has authority to decide. So my account goes. It might be a good reason though, because the legislature is standardly problematic, to introduce constitutional restrictions on top of this exercise. In a way, my discussion takes for granted those don't apply. They haven't come together.
Questions?
Yeah, I'm just wondering how the separation of powers, what does it mean here? And also, how would it really change or shape the answer or the choice between judiciary and legislature in the statutory interpretation power? So, in my opinion, one power organ, for example, the legislature, right, is in charge of making law. Then the other one, for example, the judiciary, is in charge of interpreting law. That seems to be pretty consistent with the separation of powers. So I'm just wondering, right, what it means and how it would really change your answer.
Well, in a way, I suppose I am questioning. Well, in a way, I agree that one body makes the law and the other interprets it in a sense. If by interpret, depends what one means by interprets. Mm-hmm. If one by interprets, one means ascertains the meaning thereof, finds, gives effect to, etc. And of course, the courts do that. So does everyone else, of course. So does the citizen wanting to know what he or she should do. So does the public body wanting to know what the balance of its power are. Then disputes arise about this. And the court's understanding of what the law was, what law was made. And their understanding is authoritative because they resolve disputes concerning the law and how it comes to bear. So the parallel to making law is finding and giving effect to the law. But that's not just undertaken by courts, it's undertaken by everyone. So the peculiar judicial power, I think, is adjudication. The courts, like other persons and bodies, have to understand the lawmaking act. And the lawmaking act, I think, controls the content of the law in relevant parts. It's not the only type of law, at least here you've got the law that is the constitutional and basic law, the law that is the particular legislation, common law as well. So the separation of powers, I think, is not one body is the lawmaking body, one's the interpretive body, if interpretation means can perform a function on the lawmaking act to make it something other than what it was.
Yeah, I mean, a follow-up question would be, would you make any distinction between the lawmaking power and the law interpreting power? So that's to say, if the legislature really have the power to make the law, if society has changed, you want to change your law, you should change your law. You shouldn't really do it in the name of interpreting the law. So is there really a difference between legal interpretation versus lawmaking?
Well, I've suggested there is a difference, and I think there certainly is. Now, those of my many learned colleagues, for example, who argue that interpretation is a kind of lawmaking, don't want to say it's lawmaking like legislating. They want to say it's a lawmaking that's constrained by the materials in some way, that makes something of them, that's bound to move things along a little bit. Now, I don't see the working with the legal materials that one does if one cares about the rule of law or authority or good government to involve that kind of incremental legal development of authoritative acts. It might involve the extension of authoritative acts. The question before was, am I sceptical of judicial interpretation? I'm sceptical of that type of interpretation, certainly, because I think that's a smuggling in of an illicit mode of lawmaking that isn't constitutionally licensed and that has a whole range of problematic consequences.
I suppose just to follow on from that, I mean, once the body that is doing the interpreting is itself a legislature, then maybe you look at it rather differently. And you only glossed over this. You did acknowledge that the body that interprets the basic law here is not a court, it's a legislature. But then surely the boundaries, once you have you call it pseudo legislative act, but I mean there is a body of opinion that says it is a legislative act, and it's the legislator basically supplementing the original law. Happens for, and in China they do call it legislative interpretation. Happens for various reasons. We still, from a common law perspective, look for judicial interpretation eyes, but it's something completely different.
No, sure. Well, I think it's completely different in the sense that it does have, it looks to me as though there are sort of analogues in constitutional adjudication and practice, the Canadian Supreme Court, the European Court of Human Rights, the whole idea of an instrument being a living instrument or a living constitution that one can gloss and extend and develop. It's all quite conducive to the idea that the Standing Committee could move things along, adjust them, correct them, change them as it sees fit. It might be highly problematic if what one wants is precisely to hold to the original terms of the compact and only change it when you do so deliberately. So I'm not sure it's a difference between legislature and courts, although maybe a court properly understood should be able to see its task to be to uphold prior commitments and hold the line until they are deliberately changed. I think courts should see that. It's the peculiar virtue of a court is precisely that it's structured, protected from outside influence, trained in ethos in a law school like this to think its task is to focus on the legal materials and hold the continuity of law until such time as it's authoritatively displaced. Now, I say all that, and then I know that, of course, courts don't always do that. And constitutional courts especially don't do that. Constitutional courts seem to think of themselves as peculiarly liberated from that sort of stricture and discipline. I think they're wrong to think that, although I can see why, and especially in play. I mean, the Constitution of Canada, for example, is basically unamendable, structured so their amendment procedure just can't be used. The American Constitution can be amended, it's just really, really hard, and those force a sort of pressure on adjudication as a mode of lawmaking. You can still be more disciplined and more reserved even than they are. Now, that a legislature interprets a constitution, I think, is in one way not as remarkable as our exchange might suggest, and as the use of Article 158 might suggest as well. Because the legislature in any system that has a written constitution will be subject to the constitution in part and will need to understand it to understand its authority. And so, I mean, the Americans, for example, talk sometimes about the Congress's interpretation of the Constitution.
Here they're interpreting what they probably don't think of as the Constitution, and in any event is part of a more the Standing Committee,
okay.
And in any event is part of a more general power to interpret laws. I mean, they interpret plenty of other laws which certainly would not be thought of as Constitution.
Sure. Okay. Well, my knowledge of the Standing Committee's broader position is awfully limited, and to the extent it thinks of it as a nested mode of lawmaking, then it's going to proceed differently. And it's it's not a crazy way of thinking about it, given constitutional practice more generally. And in one sense, that's why it's interesting for me to discuss this here. Basic law and its recognition and articulation of a distinct power of interpretation is a little bit at odds with the account I was giving of the separation of powers, of course. That's why it's interesting to talk about. And so it might be no surprise that the body that isn't itself subject to a constitutional order in which courts hold the line on continuity with legal materials isn't so interested in treating the legal materials like they are strictly binding. Its job is to uphold them over time. And if you give a legislature outside the system that sort of function, maybe you don't expect it to perform it in quite that way. Although maybe if I asked if there's any discussion of whether this standing interpretations by the Standing Committee could be ultra vires, whether there's any, or to what extent there is two-way dialogue about what is an appropriate interpretation or not, or whether it's just obvious that here is a subdued mode of lawmaking power that can be used to make changes on the margins, and probably you won't use it to fundamentally refashion basic law. You can use Article 159 for that, but you'll make such particular changes as you want to make by way of the article.
We have time for one final question or remark. Yes, Angela.
Yeah, if I may make one observation about separation of power in China. Actually, there's no type of separation of power in China as it exists in the Western countries. Because in China, the Supreme People's Court, has no power to interpret Constitution. It's the power to interpret the Constitution lies with the Standing Committee and the National People's Congress. So we don't, traditionally within our legal system, we don't have something parallel to the Western countries, and maybe that has something to do with how the NPC intervened to interpret the Hong Kong Basic Law.
Sorry.
If I may just very quickly add to that, I actually think the Chinese government would love your paper because I think the idea
Thank
of
you,
the
Cora.
three branches acting in coordination for the common good, rather than as some people would see that the point of separation of powers is checks and balances of creating tension and friction, rather than acting in a coordinate project to secure the common good. So the Chinese government would much favour the coordination conception of separation of powers, and I think that is actually, they expressly say that. They divide powers, but they don't separate and create tension in the way Western jurisdictions do.
They want to consolidate power, so it's easier for the parties to control.
Well, but of course, the central case that you outline is obviously, it upholds values that don't exist within the Chinese regime. But well, just to build, just a thought that came to mind.
No, it's very helpful. In one way, I think I said this in passing, but the critical separation, in one sense, is judicial power from other power, political authority from legal authority. You need that for the rule of law. In one way, I wondered if what you said, Angela, means that there is no separation of powers in China, or it means that the constitution is not really a legal constitution. And I wonder because in the United Kingdom, we also don't have our political authorities in the end, if they're acting as a sovereign parliament, are not subject to legal restraint. The basic constitutional law is Parliament may enact whatever law it wants to enact. And there are constitutional limits, and they're quite robust and important in our system. And members of Parliament, peers and MPs, sometimes argue quite fiercely about what they are. And courts sometimes comment on them without having the authority to impose them or restrain them. So there can be, I don't know if the analogue works at all, but there can be a constitution, or a small c constitution at least, that is significant and controls, which the legislature is the main mover, political authorities are the main players, decisive players, and it still has a separation of powers. Of course, further downstream, you've got a whole lot of particular positive law that's taken very seriously, that's upheld, maintained. Part of the constitution is the independence of the courts and their proper role and so forth. Maybe you don't have that in addition at that point, you don't have the separation of powers.
Yeah, I don't think we have that in English. There's no independent adjudication function, which is a very important part of your thesis, of course. So, any final questions and remarks? Well, Humphrey, okay, it's one final.
I just want to comment on the separated power point in China. Shouldn't we be? I mean, I always believe that we're asking the wrong questions when we look at Chinese constitution in China. We ask whether there is separation of power, but that is really an Anglo-American model to look at a Russian model, which descended from a completely different history. There's no concept of separation of power, and we always say that, like Mr. Kincaid said, the NPC is the NPC-SC, the Standing Committee of the National People's Congress, is the legislature. I don't think it's a legislature at all. I think the entire system is just one executive. And the other...
Exactly, well, the party
It's how the Russian looks at their constitution from the 19th century. So I think we are approaching the whole entire thing, which Article 158 is actually the interface between an old Russian system with the common law system, where the common law meets the Russians. That's how I see it. And I think the entire debate over the last 20 years or 30 years has been on the wrong premises and looking at the NPC as a legislature, and you see it in literature, in when China will fall and Pei's work. Immediately you see that you're coming in from American viewpoint. So I think there's a lot more work to do to look at the Chinese constitution, and nobody seems to be doing this. Yeah, sorry.
I'm sure there are further comments. I'm looking at Dennis, and I'm sure Dennis is thinking, I could talk about the issues that you raised about whether an NPC is interpreted to be ultravirus. In 6, maybe you need another 6 hours to talk about it. I know that you would have a lot of comments, but maybe we could continue this after this talk. And Richard has very kindly shared his paper with us. I believe Winnie has sent through the paper to those who've registered, but do you mind if we post the paper on the web of the CCBL, or do you prefer?
It's fine. I should add probably a note that's
strong.
Extremely rough.
Well, you did.
I did. Okay, fine.
Okay, yeah. So any comments could be sent to you. You have an email address there as well. So I'm sure people will be interested in reading the paper. There are some very interesting points about the approach to statutory interpretation. For example, although you're of the view that courts should look for legislative interpretation, but you actually don't support looking to legislative history as much as some people.
Nice and contradictory like that.
Yeah, but that is a very interesting point. So I do highly recommend you go through the paper if you're interested in the topic. Thank you very much, Richard.